Okay, we're live. Welcome back, committee members. We have one more item on our agenda dealing with the Wyoming Gaming Commission and some issues. And so with that, the first thing you'll see on your agenda is mention of a scrivener's error. And so I thought it might be helpful for Mr. Brody from LSO to explain what exactly that meant and what our solution is for it.
Madam Chairman, John Brody, Legislative Service Office. So to sort of begin this discussion, I just wanted to direct the committee members to three pieces of documentation that were included as part of your materials. So the first is going to be just the little bill, Wyoming Gaming Commission Scrivener Error Correction. That's going to be version 0.4. And unlike this morning, it doesn't matter what printed copy you have, the copy you have will work as far as line numbers. The other two items are going to be, the first will say original House Bill number 171 at the top. And then the second will say original Senate file number Senate file 56. So those are kind of the three things that are at play when it comes to this bill draft that's before you. Simply in basic terms, the committee will recall that in 2020, the legislature passed legislation to allow for the use and then regulation of skill-based amusement games in the state. It did that predominantly through a non-codified section that sort of laid out the regulatory framework for how those games were going to be regulated as an industry, how they were going to be taxed, and where that money that was coming from the revenues of skill-based amusement games, how that money was going to be distributed in the state. That next year, another bill came before the legislature and was adopted, and that was Senate File 56. So that'll be the second bill here, original Senate File 56. Senate File 56 did a number of things, but in a real general sense, what it did was take that non-codified law that was created by the legislature, try to rework that law, improve upon it, and then take it out of what would just be the session laws and insert it as statute into the green books that you commonly use as you're doing your day-to-day. As part of that effort, there were a number of sections within that bill. And one of those sections was section 6. It's what it's not always a section 6, but it's the section that we call the repealer section. And what we do in repealer sections, as you well know, is we get rid of statutory provisions or session law that isn't useful anymore or maybe redundant. In that bill, when the section 6 inserted the repealer, it unintentionally repealed House Bill 171 entirely. So that would be Wyoming Session Law, Chapter 114. And the problem with that is that not only did we get rid of that Section 1 non-codified law that originally had created the sort of regulatory framework for the regulation of skill-based amusement games, but it also repealed Section 2, Section 3, Section 4. Important to this discussion was the repeal of Section 2 for the most part, but that original bill made a number of changes to Wyoming statute to allow for skill-based amusement game regulation. It expanded, it changed the name of the commission. You know, it was the Parimutuel Commission prior to skill game regulation. So the name of the commission was changed. The composition of the gaming commission was changed. That was done through the codified portions of that bill. Law enforcement was provided to the gaming commission. That was part of that bill. So there were a number of mechanical changes and just supplementary changes that we did in Wyoming statute to support that non-codified section. What happened through this Scrivener's error is we intended to just repeal Section 1 because the Senate File 56 was basically recreating that regulatory framework. But because of this Scrivener's error, all of the bill went away. So in this really remarkable, and I don't know if it's ever happened before, we had this strange situation where a session law is being repealed that the second order effect is to make changes in our Wyoming statute. That is not the practice of how the Wyoming legislature amends law. For one, it's just very confusing and doesn't make sense. I think to perhaps show how maybe extraordinary this situation is, that bill moved forward as everybody read it, in the fact that we all thought that Section 1 was repealed and everything else remained in place, and the world moved forward. In middle of August of this year, we received a phone call from I would say someone within the legal division of Westlaw. Westlaw being one of the research portals, I suppose, that you can access if you're accessing case law or other legal authority. They were looking through the bills and had reached out to us because what they were looking at didn't make a whole lot of sense. As they read it, technically, it looked like it repealed statute, but they knew that's not how we would do something like that. So they called to make sure what was going on. That's all to say, in a large sense, the technical result is that the statutes that were amended through that original House bill now have been reverted back to what they were prior to this legislature's action in allowing for the regulation of skill-based amusement games. The bill before you, 22 LSO 155, is a targeted and short bill to simply try to address that error that occurred. It includes in the first section just some legislative findings, the idea being that it was never the intent of the legislature to repeal House Bill 177 in its entirety, that Senate File 56 simply wanted to get rid of that non-codified law that was recreated through Senate File 56. And for all the changes that this legislature put into the Wyoming statute as part of that initial effort to maintain those. So what this bill does is it provides legislative findings to sort of communicate that. And then in section 2, we reach into that session law that was House Bill 177, and we correct the Scrivener's error by making clear that it was section 1 that was being repealed, not chapter 114 in its entirety. Now, there were some sort of second order effects that occurred, obviously, because of this error. Section 3 is just really a sort of our attempt to communicate to whomever may be listening that law enforcement personnel that are enrolled in the Wyoming retirement system, and that their law enforcement, because of their employment with the Wyoming Gaming Commission, that their contributions and their involvement in the retirement system shall continue into the future. So this isn't necessarily binding as how you would look at a statute, but what it's trying to do is communicate the intent that those law enforcement personnel can continue to make contributions, that it's in accordance with the law, and that it can hopefully move forward undisturbed. Other than that, the bill is effective immediately. And I guess I would just emphasize that the real intent from LSO's standpoint, at least, was to be very targeted to address this problem and this problem only. I feel I need to emphasize it is very important that this issue maybe be addressed on its own merits. And I know that there's detractors of gaming. I know that there's proponents of gaming. I know that there's passions on all sides of gaming, but this really is not one of those types of pieces of legislation that is doing anything other than trying to take the intent of what has already been passed and preserve that intent. This Scrivener's error is really just kind of, like I said, it's extraordinary, and we're trying to just solve that problem as quickly as we can and as targeted as we can. So with that, I'd be happy to answer any questions.
Thank you. Questions for Mr. Brody? Senator Landon.
Madam Chairman, thank you. John, really appreciate it. I think if this moves forward, all of us are going to be asked for the talking points of it, essentially what we're putting back in. Can you, from a 30,000-foot view, just give us those bullet points one more time? What essentially are we putting back? Does that make sense?
Mr. Brody?
That would certainly help me.
Madam Chairman, Senator Landon, that certainly makes sense. I'd be happy to go into the sort of the more detail. I mean, there's really some innocuous changes that really don't really have huge effects. So for example, there's a definition in Title 6 of what constitute net proceeds in the context of skill gaming. That is certainly a term of art that the Gaming Commission, through its regulatory authority, could put a rule out and do it on its own. So that there's a number of things in the statutes that are simply like that. I'll try to address sort of the bigger points and why perhaps it's important that this bill move through. First, it changes the Gaming Commission membership. As you'll recall, 2 additional members were appointed for the commission One being a member of the tribes with gaming experience, and then another being law enforcement. So currently, as I understand it, those members of the commission still sit at commission business, but until we can address this situation, they're non-voting members. Another sort of example, and maybe a second order effect, is the committee will be well aware that there are legislative liaisons that are for the commission. Right now, there's authority to allow for those liaisons to attend executive sessions of the commission. However, the authority that created the liaisons themselves has been repealed. So there's sort of a disconnect in statute when it comes to that. I don't think those have caused any real administrative problems that I'm aware of, but those are the kind of things that are happening. You'll recall there was a provision in the initial bill that required veterans organizations, nonprofits, the folks that operate pull tabs, bingo, Calcutta wagering. The idea is that they would have to get a free license to operate, and then through that license, they would be obligated to just provide a report to the commission, just to provide pertinent information regarding the operation. So that was in that initial bill, and because of this scrivener's error, the obligation to obtain that free license and the duty to provide that report have gone away. One of the other kind of more notable things is that in the definition of peace officer in Title VII and Title VI, as you know, there's a number of different types of personnel that are included within peace officer, but law enforcement that are employed by the Wyoming Gaming Commission were included in that. And because of the scrivener's error, they no longer meet the definition, or they no longer fall under the definition of a peace officer. The reason that's important and why I raised Section 3 in the bill is that while under the retirement statutes, we identify that Wyoming Gaming Commission law enforcement personnel are qualified under the retirement system, they're qualified by reference to the definition of peace officer. So from my understanding, that's more of a technical thing and hasn't disrupted how that system is functioning with regard to those personnel. But that's just another example of why this cleanup effort is important.
Madam Chairman,
Follow-up?
thank you very much. And Mr. Brody, appreciate your memory. I participated in that bill, the original bill, and those all come back to mind, but I needed your help to do that. This other bill was a much faster paced effort, so I wasn't quite as on board with that one, but that's very helpful. Thank you.
Additional questions for Mr. Brody? Seeing none. Thank you. Well, actually, before you leave, we haven't walked through the bill, have we? It's pretty straightforward. The findings, and then Section 2 just makes the technical correction that it's Section 1 that was the only intent to be repealed. And then everything else is pretty straightforward. Did anyone have any questions about the language of this before we let Mr. Brody go? Okay, thank you. Alrighty, comments from the public? Yeah, I don't know if anyone intends on testifying. Is there anyone online that signed up to testify on this bill? I don't believe there is. Okay, seeing no public comment, committee members, just so you're aware, if you looked at the bills that were introduced for the special session, you will see that my co-chair and I have introduced this bill for the special session. Certainly, there are some less urgent things that need to be fixed, such as the parimutuel commission calling itself the parimutuel commission and not the gaming commission. But we were very concerned about the law enforcement that the commission's been able to hire, the continuation of their benefits, and then their actual ability to enforce laws as a peace officer of Wyoming. Because it had such a narrow focus to fix, a technical correction, we don't anticipate, and we would hope that the committee would help support us in making sure this is not amended. This is not intended to be a vehicle to change policy. It's a corrections bill. So for those reasons, you will see that this is on the list for tomorrow and beyond, if necessary. But in the event that this isn't taken up during the special session, we would like to have this move forward during the regular session. So with that, is there a motion to move the bill? It's been moved. seconded by Newsom. Any discussion on the bill?
Madam Chair.
Senator Landon?
Regarding your comments just made, what would it take for a bill like this to get into the session tomorrow?
That's a good question, Senator. I don't know that I have a good response.
And then I think the second piece of that committee is that would that in any way set precedents for anything else? And we can take that up tomorrow, I guess, but.
Yeah, Senator, I think that those are the arguments I'll be making. You know, for those very reasons, this is to correct an error. There's an urgency. There is an urgency, and then this shouldn't be amendable, or it shouldn't be amended. I mean, if we're staying true to correcting a technical error, my hope would be that we would pass this as it is without amendments, because it's not intended to be a policy vehicle. So those are the arguments I'll make tomorrow, depending on how the day goes.
Thank you, Madam Chair.
Madam Co-Chair?
Yes, and Madam Chairman, thank you. And Senator, to that question, I will tell you, I have spoken with the speaker, and at least in his mind, he's very clear that the session is to deal specifically with COVID-related and the mandate issue itself. And I don't get the sense that there will be any deviation from that, at least from his viewpoint. So just so you know.
Thank you, Madam Chairperson. This is to introduce this bill at the 2020 budget session. It's the Wyoming Gaming Commission Scrivener Error Correction Bill. And Senator Guru. Senator Landon. Senator Salzar. Senator Schuler. Representative Banks. Representative Haroldson. Representative Williams. Representative Jennings. Representative Knapp.
Aye.
Representative Newsom. Representative Sweeney. Representative Winter. Co-Chairman Flitner. And Chairman Ellis.
Aye, that bill passed.
Passed unanimously.
Unanimous vote, except for one excused member. All righty. Thank you, committee members. The next item on our agenda is an update on skill game licensing and expansion. I might have Mr. Brody come up again and get us up to date on where we are on this particular issue.
Madam Chairman, John Brody, Legislative Service Office. I guess, would you like me to speak to the interpretation of how skill game expansion is likely possible in the state? Is that?
Yes, thank you.
Okay. So again, Senate File 56. Senate File 56, when it initially came to the legislature, it eliminated the July 1, 2021 repeal date for the authorization of skill-based amusement games. What it didn't do was take that regulatory framework that I spoke to all about just a moment ago. It didn't take that non-codified framework and insert it into existing Wyoming statute. The reason that's important is that if we're going to have a permanent program that's going to operate into perpetuity, the appropriate way to handle a situation like that is to take the body of law, to put it into the green book so that it's available to everybody and that everybody can have access and be able to understand what the law is. So to address that situation, a substitute bill was created during the last legislative session. Substitute bills by their very nature are somewhat rushed. They don't have the luxury of going through the full LSO process because obviously we're doing a lot of things and so are you all. But so what that bill did is it tried to take the regulatory framework and put it into statute. That's largely what Senate File 56 is. And as part of that, the first provision of that bill, and you'll have to forgive me, Madam Chairman, I can't remember the statute number, but essentially subsection A of that bill said those folks that were operating skill-based amusement games in accordance with Chapter 114, which was that first bill that I mentioned to you that had the non-codified regulation. So those skill games that were operated in accordance with that law shall be authorized to essentially continue to operate skill-based amusement games in accordance with Senate File 56. Subsection B of that bill then initially said that skill-based amusement games shall be authorized to continue operating in the state if they're operating in accordance with Wyoming law or in accordance with Senate File 56. As that bill made its way through the legislative process, there was obviously a number of amendments. And one of those amendments, I believe on the House side, deleted the word continue in subsection B. So now what it says is, and I'm paraphrasing, I apologize, but essentially what it says is that skill-based amusement games shall be licensed if they're operated in accordance with this act. So that limitation of continue to operate, that word functions somewhat as a nexus between those skill games that were authorized under the original legislation and then the new sort of regulatory scheme that was created through Senate File 56. So as I understand how the situation matured, you just had a member of the public that read Senate File 56, interpreted that bill and that provision to essentially mean that if they wanted to start a skill-based amusement game and their game operated in accordance with Senate File 56, that the limitation that was imposed under the original legislation in 2020 didn't apply, and that they should be allowed to go forward and have their skill-based amusement game licensed by the Gaming Commission if it's appropriate. Shortly thereafter, I believe the commission communicated its intent to this body, and I think to anyone else, that they were going to move forward with the rulemaking process. Part of Senate File 56 required the Wyoming Gaming Commission to promulgate necessary rules for the implementation of the act and for the administration and regulation of skill-based amusement games. So through that charge, the Wyoming Gaming Commission started initiating the rulemaking process under Title 16. At this point, I think that process is ongoing. I'm not sure kind of the details of that. The Gaming Commission can probably speak to that better than I, but I'm more than happy to answer any additional questions.
Questions for Mr. Brody? Okay, seeing none. Mr. Brody, I did want to offer just a little more color to that continue to language. So when we were working on Senate File 56, for those of you who had served on that prior year's TRW committee, skill games was a topic that the committee was looking at. And the committee was unaware, from my understanding, that there were 3 lawsuits filed because there were 6, I think, total denied applicants. 3 of them had filed lawsuits. And in one of the cases had to do with this whole continue to language. And the way the Attorney General's office had fashioned their brief, their explanation for denying one of the applicants was that the games that the operator was applying to have were not turned on. And so there was this discrepancy between skill-based amusement players at the time. Those who said, I have these machines, I'm going to turn them on, and I'm going to turn them on because I think they're skill machines, they're not games of chance. And then there are other operators who said, we want to wait and see if the legislature creates a regulatory framework before we turn on our games. And so the concern was, at least from my perspective, that continue to language could have been used to hurt those operators who were waiting for Wyoming to set up a regulatory framework and were trying to follow the letter of the law. So when that Attorney General's opinion came out, it was signed in mid-February of 2021. We had already worked the bill out of the Senate. And so I visited with my House colleagues and explained the situation. And that was the reason that we took out continue to. It was, the intention of it was never to, at least from my perspective, to authorize new skill games from entering the state. I just want to add that for color. If you want, I'm happy to provide you a copy of that legal brief if that helps anybody's understanding. Additional questions for Mr. Brody? Okay, thank you. Alrighty. Yeah, Senator Landon.
And again, I'm sorry to ride a little bit slower horse here, but so when that language was stricken last session on the House side, what we, for all intents and purposes did was to throw the door open. Is that correct? I'm just trying to get my arms around where we stand today.
Yeah, Senator Landon, I can only speak for my understanding of what I worked on and what I discussed with people that were also working on that bill closely. Was our reading was that it did not open it up because you still had that existing language in A that said subject to the chapter 114 laws of 2020. And so we thought that was enough of a hook to grandfather in, if you will, those skill-based operators. We've been having an intense discussion about the interpretation of the rest of the bill. I think depending on who you talk to, there are some who believe there's only one interpretation. I'm willing to say that there are two reasonable interpretations. I think our legislative intent matters. On Senate File 56, you'll also recall that there's a section that required the commission to re-review some of those denied applicants, afford them some due process. And so if you read the whole, in my view, the whole bill together, why would we have a re-review if those denied applicants could simply reapply? So there's some clarity that could be brought to this effort for sure.
So thank you for
Follow-up?
that, Madam Chair. Just a follow-up then, I guess is where do we go from here? And I apologize if I kind of missed that, but is there something the committee needs to do at this point?
So committee members, here's how I mean, I've been giving this issue some thought, and I'll be candid with you in saying that I'm in a very awkward position. I am concerned about grandfathering in games because I don't want them to turn into liquor licenses where all of a sudden they start inflating their value just by their existence. And, you know, we'll have questions about whether or not you can sell them or transfer them and all that kind of stuff. My view was always that the expansion discussion would be an appropriate one to have once the commission got some rules under them and started, you know, we had some years of operation so we could kind of determine the effect. But here we are. I think the Attorney General's opinion is that they have to authorize new applicants and start writing rules to that effect. We've had a meeting with the governor's office and, you know, somebody from the governor's office wants to explain their position. That would be great. I don't want to speak for them. So today we could either do nothing. We have a future meeting to compensate for the meeting that we had tomorrow. But the awkward position I find myself in is saying, you know, what I presented, what I worked on and what I believed I was working on was just to grandfather it and get rid of the sunset. My co-chairwoman and I received a letter from the Northern Arapaho tribe. They do not support skill-based expansion because it infringes on their market. And I'll share that letter with members of the committee. And so I think that's the question we need to resolve today. And I'd be looking for guidance from committee members of what we should do. But I do have some thoughts once maybe we take everyone's temperature of how we can proceed with perhaps a bill draft for our next meeting. But litigation could be potential. So that's, you know, it's always better for us to try and provide clarity instead of waiting for judges to do it, in my view. But that's certainly an option. We could do nothing and let the courts sort it out.
Sure. Well, Madam Chairman, thank you. I appreciate that.
Follow up, Representative Newsom.
Thank you, Madam Chairman. I am one of those that believed when I voted to remove the words "to continue," I'm one of them that saw that as expansion. What I had heard from my constituents and people in the hospitality industry is that there were people with restaurants in Wyoming that also have restaurants in Nevada and in Montana, and they have gaming permits in Nevada and Montana. And their concern, if they just put in skill games, is that those permits in other states would be jeopardized if they just put skills games in their Wyoming restaurants. So in my opinion, it's a fairness issue to these people with restaurants and bars that did not put skill games in because they were in this gray area. And now you're rewarding those folks by doing the grandfather thing that were on the fringe of the law. And you're penalizing those that took the letter of the law very seriously. And so when I voted for that amendment to delete that to continue language, I believed I was in support of those businesses that had played by the rules all along and now should be allowed to have those skill games in their businesses. Thank you.
So with that committee, I think we can take public comments. I see we've got members from the executive branch, from the Gaming Commission here, the Pari-Mutuel Commission, however you want to refer to yourselves. Did any of you want to testify? Director Moore?
Thank you, Chairman Ellis and committee members. I'm glad to be here today. You know, this whole discussion, this whole issue, as we all know, and Senator Chairman Ellis, this has been a tough subject. It's been tough for everybody. So I'm here if you have any questions of me, the process, where we're at on this. And as you noted, I have with me today, I have my senior investigator, Mr. Laramendi. I also have David Carpenter with us today, and I have Chairman President Davis and Commissioner Covello with me today. But as we see it, there's three paths to being able to legally operate skill games. The first one is to continue to operate pursuant to 1125-301A. The second path, the commission must grant an operator permit, vendor license, or machine decal denied in 2020 upon completion of the review. The review process, we had 5 denied applicants. We have currently issued 3 of those, and we have still 2 that are out there that we're waiting on the additional information that they're required to provide to us. We're still waiting on the other 2. Then the third path is, as noted, the commission must either grant or deny an operator permit, vendor license, or machine decal within 60 days of receiving an application by any person seeking to obtain such permit, license, or decal pursuant to 1125-304A and 1125-305A. So where are we at on the rule process? As I stated in the letter to this committee, we are on track with that process. We are very close to having our first draft of rules available. We're working with Gaming Laboratories, Inc. We're not working with, or excuse me, we're following the same path and the same process that we did with online sports wagering. Working with Gaming Laboratories, Inc. We're pulling together from other jurisdictions, very similar to what we did with the online sports wagering. And we plan to have that first draft out and available for the public to review on November 1st, hopefully. We do have our November 5th meeting, and we'll have those rules available at the November 5th meeting to hear from the public, to hear from you all on the rules and the regulations that we'll have, anybody in the stakeholders. So as that process goes that I outlined to you all, we're looking somewhere between December 14th to the 27th. We would potentially have those rules out there and seek the governor's approval. The 27th of December to the 31st of December, we would start, again, this is flexible. It has to be in this process. We would commence the formal public comment. February 19th, in that area, we would hope to be completed with that formal public comment. And then around February 25th, we would respond to all those comments, make changes if necessary. Now, always bear in mind in the rule process, if we're making major changes, we have to start over again. If they're non-substantive, minimal changes, then we can continue down that road. One of the things I'm sure you want to hear is, or you want a question answered would be, what do we envision that expansion process? We don't know yet. We haven't had the public input. We haven't heard from the participants. We haven't had those opportunities yet. So what we're visioning, we don't have that vision at this point. What we do know is we hope to have 9 chapters in these rules. The first one would be the definitions. The second one would cover permits and permittees, which would include the permits generally, the fees, the applications, the decal fees. The second one would be the taxes and payments, that process, which would include taxes, payments in general, write-offs, amounts returned, and non-payments of taxes. Chapter 4 would consist of skill games in establishments. That would lay out how that process would work, and game qualifiers. That would detail the decal placement, establishment locations and restrictions. That would also include the designated areas. We would focus on that quite a bit. The payment restrictions, investigations by commission, taxation requirements, Bank Secrecy Act compliance, operator duties, and then player complaints. The 5th chapter would be skill-based amusement game standards. That would include the technical standards of these terminals. And again, what we're doing here mirrors a lot of the process we did with online sports wagering. We will continue it to the skill-based amusement games, and then we're going to move that same basic framework over to the historic racing as well. Part of the skill-based amusement game standards would be a central monitoring system, that availability, not necessarily the requirement, but the availability of that with these machines so we can embrace that technology. We have really struggled of late with some of that tracking of those games, and we've got to get that moved into a better process there. Chapter 6, transportation, receipt, disposal of skill games. Chapter 7 would cover the auditing, the internal controls on your software control measures, emergency procedures, failures to comply with requirements, independent audit of internal controls, financial audits, commission access, record retention, and then report requirements. And then the next chapter, chapter 8, would cover responsible gambling and advertising, responsible gaming plan, self-exclusions, so on and so forth. And then finally, compliance, disciplinary actions, and hearings. Again, we would mirror as much as we can, and depending on the law, what we did with the online sports wagering. And then at the end of this, we have a component that would be the procedures to become compliant and set a time. If some of these individuals that are out there currently aren't compliant, we would give a reasonable time to become compliant. So that's basically it. I don't think I have any additional items to share with you. I don't know if you do. Okay. I would stand for any questions.
Questions for Director Moore? Senator Landon?
Thank you, Madam Chairman. I don't mean to keep raising my hand, but I think this is something that we all want to get our arms around. First of all, just looking back on where we've come from, I think it's good for us to remember that about 6 or 7 years ago, as a legislature, we were sitting here knowing that we had a whole bunch of games that had moved into our state that were illegal. It was all illegal. And a couple of us put our heads together on the Appropriations Committee and realized that we needed to do something. Well, by the time that all these games were in these establishments, we certainly didn't want to jerk the rug out from underneath our small business out there. By the same token, we wanted to do bring a bill that we thought could pass. And that's why there were restrictions on that entire industry. And so I think we pulled that off. And I would say, Director Moore, I came to you with a couple of constituents who had been turned down in that process. And I appreciated the fact that you walked me through exactly why. And it boiled down to machinery and the fact that a couple of those folks had not gone through the procedures necessary to get the approval of their machines. So I appreciate that. And my question to you is that primarily, is that the main reason? Is that the hinge point for those who did not get approval? Or it doesn't really matter, but I guess that there's probably a number of things that lead to that. But it seems to me that that's really one of the main reasons, to my understanding.
Yes, thank you. I'd pass it on to Mr. Larramendi to explain that if you don't mind, Chairman.
Mr. Larramendi.
Thank you, Madam Chair. Senator Langdon. So 5 of them were denied. Of those 5, 3 have since been approved. They're operating, making good money. The other 2 were still waiting on lab reports. One of the 2 never submitted a lab report at all. Even in the under the 2020 session laws, they didn't. Another one, I've been in continual contact with the lab almost on a weekly basis, trying to get updates from them and pushing forward, but the vendor hasn't submitted the software to them yet. So we're still waiting for lab reports on those 2. Chairman Ellis, it's kind of hard without knowing which ones you're talking about to address them completely.
Sweets Amusement and the Patriot Games.
Okay, so Patriot Games, we received a lab report from 2016 that was 4 years, that was done 4 years prior to the passing of the 2020 session laws. They received an updated lab report to compare it to the stipulations of the $3 and $3,000 max bets. In these lab reports, they have statements of facts. So when you review a lab report at the end, the lab certifies X, Y, and Z. The problem that we were running into with some of these was that X, Y, and Z wasn't matching what we could see. So it said that the game functions this way, but in fact, the game doesn't function that way. It's completely opposite of what the lab report said. So the lab report doesn't match the terminals on the floor.
Mr. Larramendi, to just follow up, I've read those lab reports. They were submitted as exhibits in the court filings.
Mhm.
And those lab reports indicated as long as certain features were turned on, that they satisfied the definition of skill-based amusement games. Are you telling me that that's not accurate?
So Chairman Ellis, conversations that I've had with the lab and with the vendor themselves, when they're saying, well, we have this, this, and this, but the lab reports never outlined certain features that were demonstrated to the commission. So there was demonstrations done to the commission that of like this, trying to think how the best way to word it. Option, I would say. So this option, this option, this option. We have this, this, and this, but the lab reports never touched on any of those, which would have made those compliant from the very beginning. So when I had conversations with the lab and I asked the lab how come they weren't addressed, the lab is the ones that told us the game's changed somewhere along the way.
A follow-up question is, I think there's a little confusion too, because I was visiting with one of your commissioners, and in the Sweets case in particular, one of the requirements that, from my understanding, was that you added a definition, or the commission was requiring that the game have an opportunity to win on every play. And there was an earlier version of Senate File 56, which had that requirement. And I'll tell committee members very bluntly, I had concerns about the way that was structured because I thought it was too narrow and I was worried it would fence out other vendors and manufacturers. So we removed that language and just relied on the definition of skill-based amusement games. But then I was visiting with a commissioner and they said, no, well, we're denying those because they don't have a chance to win on every play. And I said, well, where does it say that in Senate File 56 or your rules? And it doesn't. And so that's a question I'd like to know. Are you still requiring that these vendors and manufacturers provide an opportunity to win on every play in order to be considered a skill-based amusement game under your review?
Thank you, Chairman Ellis. So under the definition in the statute, the biggest thing that we see is it says, in the definition, it says, a skill-based amusement game means a game played in exchange for consideration of cash, credit, or other thing of value on a fixed commercial electrical gaming device in which the bona fide skill of the player determined by the individual's level of strategy and skill rather than any inherent element of chance. The problem that we have with some of these is if some of these games are structured to where, say there's 1,000 puzzles, and of those 1,000 puzzles, 900 of them are guaranteed losers. Guaranteed losers. There's nothing you can do to change the outcome of that. So out of those 100 that you have left, you can use skill, but 900, which would be 90% of the time, it's chance. You're rolling the dice. If you play $1 and you get a guaranteed loser, you just lost. You don't have a choice. There's no chance or there's no element of skill that can change that.
Mr. Laramide, I think the thing I'm struggling with is that was the analysis used in the 2018 Attorney General memo. Is this a game of skill or a game of chance? So something I've been trying to work on within the context of Senate File 56. So we have more opportunities for more vendors, which is more products for our local businesses to choose from. Is how do we get away from just that analysis in the 2018 memo? And my understanding was that House Bill 171 and then Senate File 56, so that review of the game is one piece of it, but there's other controls that we have in place. We're going to limit that you can only play $3. We're going to limit that only 3,000 be the max paid out. We're going to limit that it's only for 21-year-olds or older. We're going to limit, I mean, there's so many other limitations that when you look at that whole structure, to me, the emphasis on what you're talking about isn't as perilous. Is that, does that make sense? But it's no longer in my view, and other committee members can correct. I mean, they certainly have differences of opinion, but that was my understanding, was we were trying to get away from this splitting hairs of, is it a game of chance or game of skill determined by the commission?
Madam Chair, but it's not up to us to determine that. We have to follow what is written down here to go forward. So if that's the intent, then we need to change the definition of these games to reflect what you guys are talking about here.
Chairman Davis, thank you for being with us today. You know, I think that Senate File 56 certainly needs some clarity. I think that was what I was trying to communicate and work with the commission on last year. And so that's, I think, my frustration today is I thought that's where we were headed, but I feel like we've taken a step backward. So I'd love to continue to work on this if we can find the right language that provides the clarity you need. And the reason I offer this is if you look at, and this is data you provided us earlier this year, there are a little over 800 games in the state. And this doesn't reflect the re-reviews and those new approvals, but you have one vendor who has 603 of the approved games, or 72%. The next vendor has 191 games. And so those two vendors alone comprise 95% of the market. And so I think my preference is to try and figure out a way to open up that market a little bit, to offer our small businesses that have these machines in their establishments a little room for competition, to look at games that they maybe like better, respond to the feedback of their customers, that kind of thing. But it's hard to say that we have an open market when 95% of it's controlled by two vendors. So that's just communicating my intent of why I have a problem with this. Is it a game of skill or game of chance? It's because I thought we put other controls in there. Would you be willing to work on some legislation moving forward into this next year that would maybe offer some clarity over what our intent is and how we can get there?
I believe the commission would be willing to do that. It's just, we need to understand what it is you guys want out there. And right now, we can only follow black and white. We can't interpret it, what you guys envision. And that's a key point here. What is the vision of the legislation going forward? Do we
Mr.
want it all out, or is it just going to be curtailed? You know, you said something earlier about stepping it in, you know, how did you want to come to this, to the final point of this? What steps? Do we phase it in this, and this? What is your guys' envision for us to implement? That's, I mean, we're the implementing tool of what you guys envision.
So, Mr. Chairman, just to respond, I think the question I have is, there's nowhere in 56 that we say the Attorney General's office, law enforcement, the commission itself shall determine whether or not these games are ones of skill or ones of chance. I mean, it doesn't say it in there. So I'm just trying to understand what the criteria is that you use in making some of those determinations.
Chairman Ellis, if I could respond to that. During the May meeting, I expressed my concerns to this committee that we needed to get out there and decide what Wyoming needs to look like. And you all, and I would love to work with you all in the future, today, tomorrow, next month, whatever it takes. And try to come up with a solution to this. We are always open to suggestions. We're open to assistance, anything. And so we take our direction from our legal counsel, and they guide us. And the commission makes those decisions, and then we hopefully move forward. But to your initial question, would we be interested in working with you? Absolutely. Absolutely, we'd work with anybody on this committee or anybody in the body to try to figure out how do we get to a better place.
Senator Landon.
It's sure, thank you, Madam Chairman. I appreciate your questions and thank you, gentlemen, for helping us catch up on where we stand today. It sure feels like to me that this is something that we could work on going forward. I don't know how much we can change it or fix it between now and February, being late in the interim. But I will say that this is a pretty tough area that we've asked out of our commission. And we either want this restricted a little bit, like we initially started out with, or we want it, as the representative from Cody indicated, we want it free enterprise and wide open. If we want that, then I think we've got to go to work on it and make sure that we identify exactly what that means and what, if any, kind of restrictions we want on these machines. So I don't think we're in position to be wide open right now. Although I will admit to you, I was not boots on the ground with Senate File 56. I just got behind and really didn't study as hard as I probably should have, but it just feels like to me that going forward, we may want to have the conversation of how do we open this up more? What sort of restrictions, if any, do we want to put in place? And hopefully give some guidance and help to our commission. Get us out of this position where we've got some people on the sidelines.
Thank you. Representative Sweeney.
Thank you. Thank you, Madam Chairman. So I don't want to get to a point where the skilled games become a game of chance. And if that's the problem in the definition for more clarity, but I think I thought we had already provided the tools necessary to go forth, promulgate the rules, which you're in the process of. But in the meantime, enforcing what is on the books as far as do they meet the definition according to the lab report, you know, of a skill game. And I can see what you're saying on the 900 and the, you know, the example of 900 times they're going to be guaranteed a loser. Does that meet the requirement? I guess I'm thinking it does not. But for a skill game, a game of chance, yeah. But so I don't know if that's, if I'm understanding the co-chairman, I don't know what clarity more, because it's not my intention to open it up to any game of chance on the skill game side. So.
Representative Sweeney, or Commission, do you want to respond to Representative Sweeney?
Chairman Ellis, Representative Sweeney, I think the guidance that President Davis is speaking of is the expansion. You know, we see 3 avenues and, you know, we hear the words from the committee and from a lot of people, you know, the expansion wasn't anticipated, but then we read the black and white words and the words are contrary to that, my opinion. So I think that's some of that plain guidance there is what I believe President Davis is speaking of. You know, one of the issues, if we kind of unravel some of this, if you don't mind for just a moment, I won't take too long. You know, in Wyoming, gambling is illegal, except for, and what we've done over the years, and Chairman Ellis spent a lot of time working very hard to correct that. Like what this bill changed articles and did a lot, combining things, doing it the way it should be. We stacked up, just kept stacking and stacking things on. So it kind of created this animal that we're living with today. And again, that goes back to the May meeting when I'd said, well, you know, in my opinion is we've got to sit back down, work with this committee or other committees, and we've got to come up with some general where it is, what we have to do, and then move this forward. It seems like a lot of times thank you, Senator Ellis, for saying it feels like we're backing and forth and we're backing up. We move forward in our office and then it seems like there's a backup. And I don't mind backing up as long as my next step is moving forward a little more, because it's my job to move this forward at the end of the day. I kind of went off in a different direction and I apologize, Chairman Ellis, Representative Sweeney, but I think the guidance goes back to the expansion issue, I believe.
Thank you, Commissioner Dave, or excuse me, Chairman. Let me also just add this. So I know we want to get off the topic of these lab reports, but they're a little essential to what the next step is to think this through. If we expand and allow new games to come in through affirmative legislation, then you're going to have new vendors who are going to still have the same problem of, well, I've got this lab report who says it's a skill, and then the commission saying, well, no, we don't think it is. Like, so we need to figure this out one way or another. I think the concern that I have with the example that was provided was there are 900 winning combos, but you know, only, or 900 possible outcomes, but you're only going to have a successful outcome 100 times. There's a difference in, again, Indian gaming between a casino style slot machine that has infinite numbers of possibilities versus those that have a finite number of predetermined outcomes. In Wyoming, we allow historic horse racing machines, which have a predetermined number of outcomes contained within the machine to determine the game. So in my view, if you're trying to look at the threat that these machines have to the public and being wagering or offering some form of gambling, to me, they're the same. And so that's where I push back a little bit on this notion that because there's an element of chance in the skill game, that it must be a prohibited gambling activity when we look at historic horse racing machines, it's permitted. So to me, they're very similar. So that's why I push on that definition a little bit. Okay, any other questions? Chair, comment from the
Madam
chairman?
Chair, you know, part of the report and the commission is to establish the checks and balances so that when we approve it. So as Nick reflected, is that we have checks and balances and the report has checks and balances. And if they don't meet together, then we don't have a good report or good game out there. So it's a combination of both. I mean, the commission needs to have them checks in place so that these games do meet the requirements of the state of Wyoming.
Thank you, Chairman Davis. I'll just express my policy preference would be like going to get your driver's license. You show up with the right forms of identification, check. You take the test, check. You pass the vision test, check. You get your license. In my view, the lab report is you're a vendor, you go to a lab, check. Not submit it and then have to go through additional scrutiny, make changes to your game, get another lab report. That's my preference. And so I don't, that's the thing I'm a little confused on. Representative Newsom.
So in that scenario, if I just go get a lab report and it does not comply, I've still checked that box. So I think that the compliance piece is the issue. The report has to comply. So it's like, oh, I went and got my driver's license. I took the test. Well, I didn't pass, but you should give me my driver's license. I'm not following.
Representative Newsom, to clarify, the lab reports that I've seen that the denied applicants have all indicated that they are skill machines that satisfy the definition. So if they didn't satisfy the definition according to the report, then no, I wouldn't think they make that check. Representative Flitner.
Madam Chairman, thank you. So my question, I guess, to Mr. Laramendi. So if you have an analysis done, if the problem is that they come back and say that it meets the definition of skill, but yet you guys determine that it does not, is the problem with who they go to for the analysis of the machines? And I'm wondering if we have a better relationship or find a company or whatever that does that analysis on those machines that does comply with our definition of what it means to be a game of skill. Does that make sense?
Mr. Laramendi.
Thank you, Madam Chair, Madam Co-Chair. So I think part of the problem that we ran into, especially early on last year, is this was a very new thing for Wyoming. These labs test for jurisdictions nationwide, and every jurisdiction has kind of a different understanding on what skill is. There's one jurisdiction for skill games. Their definition of skill is if you can find the location of where the game's at, you exercise skill to get there. The fact that you drove there, that's the skill you exercised. So these labs, when we first came into this fresh, and we've been working with the lab since, trying to say, okay, like this is kind of, what we're looking for, and this is what the statutes say. And because originally, they were looking at $3, $3,000. That's what they were testing for. They're pulling machines and they're like, well, the statute says $3, $3,000. The max bet on this machine's $2. The max payout's $2,000. So it passes because it passes. So we've been working with the lab trying to get some more clarification on like, this is what the definition of a skill game is. What can you test for that means that it matches the any inherent element of chance? What kind of testing can a lab do to tell us if there's any inherent element of chance? If they can come up with a testing procedure for that, and it shows that there's an inherent element of chance, then it wouldn't get the pass on the lab report. Last year, the problem that we had is the labs weren't testing for that. They were testing for $3 and $3,000, and really the rest was up to the commission. So we had to compare the lab report, the facts of the lab report to what we were seeing on the floor to seeing if they matched. And on some of them, they didn't match.
Further questions? Further questions? Ready, thank you. Would anyone else like to testify? Mr. Mosier?
Madam Chairman, members of the committee, Mike Mosier, Wyoming State Liquor Association. Just to clarify a couple things before we start out. We supported the cap of 4 games. We still support the cap of 4 games. We want the focus of our businesses to remain being restaurants, bars, fraternal organizations, not gaming establishments. Games of skill pass a criteria to make sure that they are entertainment devices that require a heavy component of skill. We support keeping it that way. I've represented, well, actually, I've worked with gaming issues for several decades plus, and I still get calls every week or two from some retailers saying, hey, some dude just put an e-pull tab machine in my game and he said they're legal by the state of Wyoming. All the time, e-bingo, e-pull tabs, you name it. And of course, it's no, get rid of it, there's a fine. And so I really like what we've done because we've actually put teeth in some of the enforcement on some of these fly-by-nighters who do come in. And Senate File 56 and House Bill 171 came a long way in dealing with those issues. We support, and I hesitate to use the word expansion, because in what we're talking about, we're not creating new forms of gaming. We are just allowing businesses who didn't get those games before the deadline to have them, and I'll elaborate more. We have always had 2 goals. The Wyoming State Liquor Association, eliminating the sunset that was done, and eliminating we're allowing expansion, which I didn't think was done, but apparently was. The only bar exam I've ever passed was owning a bar. And so I didn't really realize it had happened. My first newsletter that went out in the spring at the end of April said, hey, we got the sunset removed, but we still need to work on expansion. The last newsletter that went out about 2 weeks ago said, I guess we have expansion, but don't let anything run until the rules are adopted. So things have changed. Now, the big reason, ladies and gentlemen of the committee, that we support allowing expansion is fairness. Because there are a lot of businesses out there. Now I'm going to promote sideboards, heavy sideboards, because we really need to watch who gets these machines. You don't want them in the basement of a church. You don't want them in every antique shop in downtown Cheyenne. But on the other hand, I'll give you a couple examples. There's an establishment, well, several establishments, but one good example, who one of the owners happens to be a retired higher level municipal official. And he called me and he said, we want these things. Are they legal? And this was before House Bill 171. And I said, well, they're not illegal, but there's nothing in statute that authorizes them. And he said, once they're authorized, you call me and we'll put them in. Well, by the time I called him, he couldn't put them in. And so if you've got anybody in a position like that, that's a co-owner or a board member, and when I say board or officer members, fraternal organizations, there are a number of fraternal organizations that didn't want to put in skill games until they were authorized in statute. Near and dear to me and some of your hearts are veterans organizations. If you've got a officer who's law enforcement, he's going, no, not till it's in statute. Well, bang, it's in statute, bang, you can't put them in. And so we're creating winners and losers. Also, there are there's one of my favorite restaurants north of town. The skill games provider that they signed with was determined non-compliant. They even built 4 little niches for them. Well, they had to shut down, and because of the shutdown on any expansion, they still don't have games, even though they had operating ones before House Bill 171. Lastly, some of you guys, and I'm not throwing stones at these areas because I'm from about as podunk area as you can possibly get, but salespeople never called on them. And so I was getting calls from retailers saying, hey, we want these games. It's like, dude, it's too late. The sunsets, the deadlines hit. You can't get them. Well, nobody ever called on me. The only time I ever read about them was in the newsletter. Well, That's just what happened. Now, do I think those businesses, the vast majority small businesses, should be able to get skill games? Yes. And I'll give you a good way to be able to allow that. Expansion exists. We weren't quite sure how it existed until recent months. Like I said, my spring newsletter said hadn't been done completely yet, but turns out it looks like we're there. And I'll give you an example, and it was actually an amendment of the House, and I believe Representative Newsom has some guides on this. We need sideboards. Expansion's going to happen. They're drafting rules. On the other hand, they can't draft statute. And in my opinion, we need statute that strictly limits the types of businesses that can get skill games, which by in itself will inherently considerably reduce the number of businesses who can have these. Limit them, number one, to liquor licenses, with one exception, and I'll outline it. And I'll give you the numbers as we go through this because it's not near as many as people think. Full retail liquor licenses, yes, those are the Cadillacs. Those are the ones you can do bars, packaged liquor, restaurants, whatever you want to. There are about 790 in the state of Wyoming. Many of those businesses that are full retail licenses do not want skill games. If you're a standalone packaged liquor store, Del Range, if you drive down Del Range, the significant majority of those corporate chain restaurants, large chain restaurants, have full retail licenses. They don't want skill games. That's not even in their corporate structure. So out of those 790, some of them already have skill games. In fact, a bunch of them do, but also subtract the places that wouldn't be interested in the first place. Also, bar and grill licenses. There are about 85 bar and grill licenses in the state of Wyoming. Once again, a lot of those are corporate restaurants, so they won't be interested. Limited retail, which most of us would know as club licenses. A lot of them already have skill games. I think that's one sector that's really missing out because there was so much hesitancy until it was statutory. For example, one of my favorite Legions, I mean, they didn't want to risk losing their charter by illegal gambling. Well, don't blame them. Well, once again, we made it legal and now you can't do it. Also, resort licenses, which are able to serve alcohol anywhere on their property. There are only, at least as of a year ago, there were only 39 of those. And which comes to about 1,000 total. Now, bear in mind, there's over 300 businesses right now that are currently operating skill games. A significant number of those are already have skill games. A significant number are full retail licenses, although lots of clubs and stuff. So you take that 1,000, reduce it by about 250, then you're going to reduce it by at least half by the places who don't want it. If you blow this out by just allowing liquor licensees, you may be talking doubling the amount of businesses that currently operate them. The vast majority small businesses are clubs. So that's a pretty limited expansion, and those are easy sideboards to put on. Lastly, and there is consideration, and we're fine with this, is truck stops, but make it a really precise definition of truck stops. X number of parking spaces, X number of volume and gas, whatever. You don't want the local C-store down the street to have it if they don't have a liquor license, if they only have 5 parking spaces. And like I said, the specter, if we don't put sideboards up, is particularly scary to me. I'm not a pro gaming guy. And on this issue, ladies and gentlemen, I'm reminded of, and as Mr. Larson mentioned earlier, I'm probably about the only one going to be around here that worked the lottery bill. Much talk was about Keno. Keno was an oops. I had a call after the bill was signed about 2 months afterwards, and it was a gaming company, and they said, y'all realized you legalized Keno, right? And I said, what's a Keno? Is that like that bingo thing? And they said, yeah. And turns out it's not instant win. And we didn't know that till afterwards. Stuff happens. In this case, I have to be honest to committee, whether this was intended or not, and some knew about it, some didn't, I didn't, but I'm tickled to death about it because I think these businesses that missed out on an opportunity to help make their businesses successful or their clubs successful deserve that chance, just like the existing businesses that have them do. Without sideboards, we're looking at a train wreck. We need sideboards to be able to say these businesses can, these businesses can't. There's some uncertainty whether the parimutuel commission or gaming commission or whatever you are has the authority to do that. you have the authority. And I would really recommend that. Once again, we advocate limited gaming with strict sideboards, with strict standards on who can operate, what types of machines they can, because we're the ones that end up paying the penalties if something's wrong. And we want our customers treated fairly. So that is my solution. I don't know if it's an elegant solution. I don't even know if it's moderately attractive, but it's a wonderful way to take what we've got, because we've got expansion. Take what we've got, put a narrow focus on it to those of us who already deal with age-restricted products, in some cases, several of them, and help some of the businesses I'm sure all of you have in your communities. And Madam Chairman, I will take questions.
Questions for Mr. Mosier? Representative Sweeney?
So, thank you, Mr. Mosier. So in your opinion, if we moved forward with the sideboards, does the current legislation also restrict if somebody wants to come in, another company other than to provide machines and another operator, are we currently restricted without moving forward with expansion on new, I'll use the word operator, but I don't think that's the right word, but on if there's another other than Cowboy Skills or Pace-O-Matic or whatever?
Madam Chairman,
Mr. Mosier?
Representative Sweeney, and I believe, what, 5 out of 7 of the applicants have been approved. There should be standards because somebody's going to take advantage of this. One thing I learned early on in the gaming world is there's lots of wonderful people. There's a lot of other people just looking for loopholes. And you need strict standards to keep it fair and keep it fair to my people and keep it fair to your fellow people who play this. I'm not an expert like Madam Chairman is. I can't tell you this is a good lab report, this is a bad lab report. I just know you need strict standards. You need to have the ability to deny machines and to approve them. The majority, 5 out of 7 have been approved. I don't know the details as to why the other 2 haven't been. In fact, I'm not even sure who all of them are. But you definitely need standards for that approval process, because games of chance make me queasy, because then you open a big old gate to all sorts of stuff. And I don't like that stuff. I mean, to be honest, I'm not a gambler. I cry myself to sleep if I lose $10 on a Cowboy game. And so gaming has never been my thing, but if you're going to do it, make it fair. And that's why things like lab reports, whether these are the right ones or the wrong ones, but that's why they're so important, is you need to have, some of you might remember, those of you in Casper, there was e-bingo. And we did that legislation probably 12, 14 years ago, because there was a loophole about e-bingo, and several establishments opened up and made a boatload of money before we finally did legislation, Senate File 23, if I remember correctly, to say you can't do e-bingo. I mean, if you got a loophole, they'll find it, because and they aren't normally in-state people. Most of our in-state people I feel pretty good about, but you don't want those doors open. I hope that helps, Representative Sweeney.
Vice Chair Schuler?
Thank you, Madam Chair. I've just, you'd mentioned briefly truck stops, and I know with the statute where they have to be 21 to be able to go into that establishment. Would that be difficult for a truck stop to be able to, regulate that? Thank you.
Mr. Mosier?
Madam Chairman, Senator Schuler, I think that's something that really needs watched. And I think that's why these guys need the ability to deny, because that way you can see how the layout is. I mean, for example, a bar and grill liquor license, you can let kids in some of those areas, but you need to have a clearly delineated age limited area for the skill games. The ones that worry me is right now you have some convenience stores without liquor, without anything, that just basically have a sidebar with a little wall that says nobody in. Well, nobody's watching it. I mean, you could have a daycare there for all you know. And so I'm okay with the idea of truck stops. Admittedly, I don't represent truck stops, but I can understand it. But they need to be able to look at it and go, no. This is not a wall. This is not appropriate. And that's why, even though I don't always agree with the guys behind me, I really approve of enforcement. Those of us in the liquor industry are about as highly regulated as you can possibly get, and we actually like it because it keeps bad operators out.
Further questions for Mr. Mosher? Mr. Mosher, I remember there was an amendment on the House side that would have authorized truck stops and liquor licenses. That didn't pass, did it?
Madam Chairman, it did not pass. I think some of it may have been there may have been some people in the House that understood that was already expansion there. We didn't know. I lobbied like crazy to get it on, but I don't know the details of why it didn't pass. However, I think that conversation has changed somewhat because we found that skill games in a limited capacity are not a nefarious influence in our communities nor our small businesses, as long as they're strictly limited. So no, it did not pass. It did have some of the same language that I described. The only difference is I believe the amendment had restaurant licenses in it. And I'm kind of torn on restaurant licenses because the primary idea of a restaurant liquor license is you're supposed to serve food. There are approximately 258 restaurant licenses. When I say approximately, my numbers are year-old, so there's a few that may have come and went. But since a restaurant license really doesn't have a bar area, if you want to put in restaurant licenses, that's fine. If not, I haven't had any restaurants going, ooh, ooh, ooh. So I'm fine one way or the other. But yeah, I think the amendment had a lot of the same language that I described.
Further questions? Senator Landon?
Thank you, Madam Chairman. So, Mr. Moser, I'm just sitting here wondering if we wanted to stand something up pretty quickly, would you be able to rally your industry and all 600 or 800 of these properties that you alluded to? You know, a bill like this takes a little bit of effort to gather up, lock the gates, get everything in the corral, and be able to present it and take it forward. The committee, I don't think probably can do that now because we're at the end of an interim, and it really wasn't one of our elevated topics. So my question is, could we make it to the finish line with a product that you think would be sufficient?
Mr. Mosher?
Madam Chairman, Senator Landon, yes. I mean, I would like to have a committee bill along the, I think it was Representative Walters that did the amendment in the House, if I remember correctly, with the sideboards. But if it isn't a committee bill, no, my retailers really want this. And even the ones who have the games are going, come on, guys, really? The guy next door, he just didn't make a phone call. And so I think you have a lot of widespread support. Fraternal organizations, oh yeah, we'll get some action on that because a lot of them are still struggling through COVID. Fraternal organizations also have a double-edged sword of having the difficulties with just membership in general. Or people like me with veterans organizations, all of us being old fossils and stuff. So I think we could build a common front. However, I would love to have legislative support for such a move. But I believe we could get quite a group.
Thank you.
Further questions? Thank you, Mr. Mosher.
Thank you, Madam Chairman.
Is there anyone else in the audience that'd like to testify? Jonathan Downing? I apologize. We have some Senate leadership here. Majority Floor Leader, Senate President. Gentlemen, would either of you like to make remarks or do you want to listen a little bit more? Welcome. Ms. Wilkinson and Mr. Downing.
Good afternoon. Excuse me, Madam Chairman, members of the committee, Catherine Wilkinson and Jonathan Downing on behalf of Cowboy Skill Pacematic of Wyoming. Excuse me. Madam Chairman, we are here today just to offer a few comments on if the committee should take up the issue of expansion. When we discovered that there was full expansion in the bill, we worked right away to send a couple of different rules to the Gaming Commission because it is our belief that there is full expansion in the bill. And we have always advocated for age appropriate locations of skill games. And so Madam Chairman, excuse me, we have some proposals that are submitted in front of you should the committee take up this policy. We do believe that they do need to be limited along the lines of what Mr. Mosher suggested to liquor licenses and truck stops. Madam Chairman, I would point out In the proposed amendments that I sent you, we inadvertently left off resort licenses on page 2. And it would go just after, it would be 12-4-401. That was inadvertently left out in the proposal and amendments. However, it is listed in the committee reference for statutes. Madam Chairman, we have come to this committee and the legislature several times seeking for regulation for skill games. Gaming is an area that we do believe requires regulation, and it is very important that these games go into those locations that are appropriate and restrict that growth to a responsible manner. Madam Chairman, sorry. I believe that those are all my comments. Mr. Downing may have something more to add, and we would stand for any questions you may have.
Questions for Ms. Wilkinson? Ms. Wilkinson, when we worked on Senate File 56 and you were reading it, correct me if I'm wrong, but you were very concerned about seeking expansion because I think the concern was from your industry was that it was seeking too much too fast and it might jeopardize the entire bill. Is that a legitimate way of paraphrasing your concern at the time?
Madam Chairman, our first concern was lifting the sunset for our vendors. And I would remind the committee, we do have 8 vendors that are competing vendors across the state that have chosen the product of Pace-O-Matic. So our number one concern was absolutely the sunset and advocating that that be removed. When we thought the issue of expansion came up on the House, that was the Walters Amendment that you had referred to before. And that's why we were advocating for these sideboards to be put in place, because it is very important that there's responsible growth in this area. And the way it is now, Madam Chairman, the games could go anywhere. And I don't believe the commission has the ability to deny any of the game applicants as long as they check all of the boxes.
When
So
did you first become aware of the language or read the bill and say, oh, I think this is interpreted to authorize new applicants to apply? When did that happen?
Madam Chairman, it was shortly after the bill was signed and I received I printed out the enrolled copy and read it. And it was then that we, had some conversations with legislators and also sent some proposed rules that contain these exact same recommendations to the Gaming Commission. We provided them 2 sets of draft rules, one that we based off of the statutory framework of Senate File 56, and the second at the request of Director Moore that were based more along the sports wagering guidelines that had a little bit more meat in them, but both of them have contained it. But it was right after the signing, and we were finally able to see the fully printed out version of the Enrolled Act, Madam Chairman.
Thank you, Ms. Wilkinson. I just want to make sure I didn't miss anything. Did you provide that legal analysis or those draft rules to the TRW committee in May or in August?
Madam Chairman, we did have a draft. I'm not sure if it was distributed to the full committee, but I do have all the drafts. We've had different iterations that have basically copied and pasted for all of your meetings, the May and, forgive me, September, whenever the last one was in Du Bois.
Questions, committee? Seeing none, thank you. Mr. Agopian?
Madam Chairwoman, members of the committee, my name is Nick Agopian. I represent Bankshot LLC. I think we're one of the minority market shareholders in the skills games industry that you were referring to earlier. Today with the discussion, I don't know that I have a ton to offer in addition to what's already been said. We agree with the discussion around where the statute currently sits and the ability to expand under the current law. But in that belief, we also need to stay true to what the statute says, and that means having rules in place to do so. So we remain focused on those rules. We believe a lot, or I believe, as I'm learning more and more daily about this industry, because I'm far from an expert, that the rulemaking process itself and the industry-wide standards in this country will address a lot of those questions. And beyond just the approval or being an approved lab, more importantly, will be the standards that the commission comes up with that the operator of the game sends with the game and the software to the lab to review against. An approved lab being approved to review against the standards set by the state seems to be the next logical step to determine is the statutory framework sufficient? Are the rules sufficient to move forward? And where do we need to correct that statutory authority if necessary going forward? So with that, I would stand for any questions. I thank the committee for its time and interest in this issue. It's certainly the potential for this industry is significant. And we're confident working with the commission that we'll get there. But to that point about rulemaking and the discussion around legislation, the sideboards piece, I think generally without seeing it, we're probably okay with it. I think with what's been talked about with truck stops and liquor licenses and establishments like that makes sense. But having a discussion about expansion in some of these sideboards ahead of the rules, not only could provide more clarification, but it has a potential, I think, when you look at that timeline, to push out the establishment of rules. If this legislature were to change the statute again, and it was effective immediately the middle of March, that would be just a month after the soonest the commission has identified they would be prepared to enact a rule or get it to a governor. I'd have to look more specifically at that timeline that was in the document shared. So just a comment, I guess. And thank you again for your time, and thank you for letting me speak. And with that, I would stand for questions.
Questions for Mr. Agopian? Mr. Agopian, does Bank Shot have games currently in truck stops?
I believe so, yes.
Do you know if some of those contracts allow for exclusivity?
I can't speak to the details of those contracts between the location and the vendor.
Do you know primarily where those games are located for your client?
Where they're located
Like
within
in
the
truck stops or mix of truck stops and restaurants? Do you have a sense of how where those are located?
Madam Chairwoman, I would have to get back to you with that percentage, but I do believe all of that information is available through the commission website as it identifies utilizing Google Maps where all those locations are and what they are. But the extent of the detail of that information, I'm not familiar with offhand. So I would be happy to provide that information.
Thank you, Mr. Agopian. Any other questions? Seeing none, thank you. Would anyone else like to testify on this topic? And then I do think we had a Mr. Armitage. Is he available?
I am, Madam Chair.
Hi,
Hi,
welcome.
my name is Terry Armitage. I'm with the Wyoming Association of Sheriffs and Chiefs of Police. So I'd like to give a little bit of input from the law enforcement perspective. By way of background, I've been an attorney in Wyoming for 30 plus years. Half of my career was at the Attorney General's office, the other half in private practice. In 1986, I was assigned representation of the Parimutuel Commission. So I became well-versed in gambling law, horse racing, and everything that goes with that. And I got to watch the evolution of gambling in Wyoming over the last several decades. And I've seen it go from relatively simple to incredibly complex. I had advocated for a gaming commission for decades, and I'm thrilled that we finally have one. The United States Supreme Court ruled many years ago that gambling is a closely regulated industry. The Wyoming Supreme Court has said the same thing. It needs to be closely regulated. So my first thought would be, you might want to give your new gaming commission a little bit of elbow room to develop the rules and regulations to oversee all of the gambling that they're assigned to oversee now. Because gambling inherently brings in a certain criminal element from time to time. And it takes close regulation and good law enforcement and good investigation to keep everything above board. I think we're well on our way to getting there now that we have a commission. We need to let them promulgate those good, solid regulations and rules so that they can do their job and control all this. I think that's crucial. In doing so, I'd ask the legislature to consider making sure that the new gaming commission has the resources and the manpower necessary to do this job. These skill games, or gray games as they're called in other states, are complicated. It would have been easier, I guess, to legalize simple slot machines because they're a game of chance and we know they are. These skill games are something in between. It causes the need for lab reports and analysis, but that's where we are. So I think if we give our commission a chance to work through that, get their feet on the ground, they'll have it under control. I don't doubt that. And then with other gambling coming up, such as the sports wagering and whatever else may be coming out there, they're going to have their hands full because again, this needs to be closely regulated in all aspects. They need good law enforcement folks with them, and they need people with the expertise to understand skill games and online wagering and whatever the case may be. So I think given a little bit of time and a chance to get it figured out, I think this new commission is going to be doing just fine down the road. One thought I have is I think now that we have a gambling commission, all gambling activity that's legal in the state needs to be under the authority of your gaming commission. Earlier today, I realized we have a lottery out there now that is not by statute regulated by our gaming commission, something you might want to think about. I think all gambling should be subject to the same supervision that we have in place now for some of our gambling, but not all. And with that, I'd stand for questions.
Questions for Mr. Armitage? Seeing none, thank you for your comments today.
Thank you.
Is there anyone else in the public that would like to testify? Seeing none, public comment is closed. Committee. So there were a couple of paths presented. We could do nothing. We could affirmatively pass some kind of legislation or ask LSO to draft legislation for our next meeting that says, yes, the intent was to allow for new applications. Or we could proceed in the other direction and instruct LSO to do a bill draft saying, no, our intent was not to allow for expansion or taking new applications. I think my co-chair and I have talked about trying to find a date in January when we can finish all the business that we had planned for yesterday. We do have more bill drafts and work that we need to finish. But certainly between now and then, we could have a bill draft ready for your consideration at that future meeting when that's determined, and we're working on all of that. My preference would be to do something affirmatively one way or another. I think leaving it ambiguous requires, could cost litigation or produce litigation, which is costly for everyone. And then we're letting the courts pick our intent rather than us just working on our laws and making them clear. So with that, I do want to get a sense of the committee of which direction, if you're willing to entertain some legislation. The unfortunate thing is I really wish we had been working on this the entire year, but it was not an approved interim topic until we started hearing more concerns. But I think you've heard today, there's a lot of things we need to sort out. So with that, I'd open this up to any comments from members of which direction you'd like to go. Should we affirmatively say we'd like to expand gaming or skill gaming, or should we go the other way? Representative Newsom.
I would like to address the expansion piece by doing legislation that clearly states that we have expansion. But the other thing I would like to do in a separate bill is to put these sideboards on with that skill games can be in liquor establishments with liquor licenses and truck stops and do those definitions as suggested by Cowboy Skill, maybe looking at those. And so I would like to see two separate bills.
Additional comments from the committee? Senator Landon, and then Vice Chair Schuler, and then I'll come around this way.
Madam Chairman, thank you. I've really appreciated all the comments today. Appreciate the commission and the agency folks for being here and the work they're doing. With that in the background, I've sat down with Mr. Moore several times to talk about the lift that we have given them over the last 3 or 4 years. And incidentally, we have from the last meeting, the idea that our committee is going to send to the Appropriations Committee, look, we'd better take a look at maybe giving some help to our gaming commission so that they can do this job. All of that said, I'm sure compelled to go with Representative Newsom. I really think there were some good points made with respect to the expansion. So if we take something up in January, say, that seems to make some sense to me. You know, the whole idea of free enterprise but my only caution is we need to work hard to try to make sure that legislation is good. And I agree with the co-chairman. You know, I wish we'd have had the interim to work this really hard all the way through. And so this is a lift for a couple months from now.
Further comments from committee members? Representative Banks?
I would just concur with Representative Newsom and Senator Landon that I think limited expansion would be helpful and give new opportunities to new merchants that are opening potentially or that want to expand. So I would support that as well.
Additional comments? Oh, so sorry, I skipped over you. Madam Vice Chair.
I'm standing awful close to you, so it could happen. Thank you, Madam Chair. No, I would absolutely reiterate what the two representatives and my senator here have mentioned. And I think the reason for that is that it kind of gives us some time to get the word out that we're taking a look. And these people that have felt like that it was unfair, that they didn't get a chance to, you know, an opportunity to have a skill game because of the way they interpreted it and maybe the way we had it in there. I think this gives them an opportunity to maybe offer some potential ideas. I like what Cowboy Skill, some of the amendments that they have offered, and I just feel like that in the spirit of transparency, it gives us an opportunity as a group to take a look and see if there's other things we've maybe missed or that we need to do. And I would like the idea of two bills rather than just one, so that we can kind of get the sideboard set up. Because not knowing that we already had some of them in the truck stops, I thought that was interesting that they're there already. But I also know that they're convenience stores. And so I think we do need sideboards, and I think we need the transparency. This gives us some time. And as long as we have time during that meeting to bring forth two bills, I would definitely jump on that board. Thank you.
Other comments?
Thank you, Madam Chairman. Really more of a question, I guess, to the chairs, because my concern here is that I've been in on hearing these bills now for a number of years, and I'm glad we've moved forward, I guess. But this seems like a fairly heavy lift. We have one day left, and we have a number of bills to work, I think, on that last day. But I guess that's part of my question. And so I'm just curious from the chairs, you know, one day we already have pretty well lined up. Now we're going to go through two more bills on a subject matter that I think is pretty important to the people of Wyoming. So I guess that's my question, Madam Chairman.
Madam Co-Chair, did you have a comment?
I did, yeah, Madam Chairman, and yes, Representative Jennings. And we have one day already on our docket, which we banked, but we have already spoken with leadership. And I believe that it is their intention to go to Management Council and see if we might get a second day. So it is conceivable that we would have 2 days in January to not only address what was on our agenda for tomorrow, but also to address this issue.
Senator Landon?
Madam Chairman, thank you. I really appreciate the representative bringing that up. I think we're all cognizant of how late in the interim we are. And the other thing that it kind of dawns on me is that our staff has really been thrown a little bit of a curveball this week. I'm on a couple of committees that are really struggling to even get to a draft stage on some things. So as long as we remember that, and as long as when we get to January, I hope we'll work hard to make sure that that bill, if there is one, let's just make sure that it's worthy of going to the session with. And I bet we can do that, but we haven't had the time to devote to it, as the representative pointed out. So just a couple of cautions there. If it isn't there, we've got next interim to make sure we get it right.
Thank you, Senator Landon. I do want to offer, in some conversations I've heard, there is a possibility and potential for litigation. So I don't know that we have the luxury of waiting unless we are comfortable with the courts taking this on, and then the cost to the litigants, and maybe we're fine with that. That's actually, you know, if they want to sue, that's anyone's choice anytime. I can tell you, I think about this. We haven't thought out all the issues, and in working on Senate File 56, and picking up House Bill 171, there needs to be more discussion, I think, and I think we can produce a good bill by January if that's when we end up meeting. What we've done in other committees that I've been working on this interim is little work groups. And so anyone that wants to participate in those, we'll set up a Zoom call. We'll go through potential legislation. I'm happy to take a crack at some early drafts to circulate for folks. We can walk through it. If you can make those calls, great. If not, we'll send out emails updating you on how that work progresses. But you have my commitment to try and improve this because I don't think we've threaded the needle. And I think we need to be clearer. And I think that I think we can get some good work done before our next meeting. Any other comments, Representative Haroldson?
Thank you, Madam Chairman. One other thing I think we need to definitely consider, if we're going to consider expansion, that we have a really good definition if these are a skill-based game or if they're a chance game. Because at the end of the day, I mean, skill-based and chance are completely different. If it's a deal where you're guaranteed a win if you're capable of getting that win is completely different than a slot machine type concept. So I think as we look at expansion, we also need to look at these lab reports actually showing us if these are a skill-based or if they're a game of chance. And so I think that has to be, for me at least, is a hinge point as we move forward.
Good point. I will send to anyone that wants to continue to work on this, some of those court filings. You can actually read some of the lab reports. None of the ones I read said that that was what contained the skill. They all looked at the mechanics of the machine. Okay, I think that's helpful. So I will work with LSO. Does anyone want to go down the other path though of, no, we did not mean expansion? Okay. Language saying, drafting language saying, no, we did not intend to expand and we don't want to go down that path. Did anyone want to explore that possibility? I know. Okay. So other things I'm thinking about are, if not, we're not going down this grandfathering path. We do need to give some thought to these the lab reports, the definition of skill, and have a little bit more of a robust conversation of what that is. And I will tell you, that is my biggest concern is I just don't like creating a monopoly. And we have 95% for two of the vendors. And that Pacematic and Bank Shot, 95%. So that's a concern of mine. And then we probably don't need to do this. One other issue, committee members, I was at Select Tribal and I was visiting with our Division of Criminal Investigations about the Missing Murdered Indigenous Women Bill that we passed a few years ago. And I asked him about the number of background checks that they've had to perform as a result of Senate File 56. Certainly it wasn't our intent to do an unfunded mandate. So part of this work, I would like to reach out to DCI and the commission to figure out a mechanism, either through the fee structure or within the revenue that the commission generates to offset some of the cost and impact that that's had at DCI in processing these applications. Certainly, if we go down the path of opening it up for new games, there'll be new applicants, and we want to make sure that they've got the resources on that front. So I'd anticipate that as well. Any other issues that you'd like to discuss? This, and just out of show of hands, who would like to form a working group to get a bill draft or to work a bill draft? Okay. So I have Newsom, Sweeney, Hutching, or excuse me, Schuler, Landon. Hey, Lynn. Okay. Oh, Littner. Okay. Yep, Senator Landon.
While you're writing, I was just going to throw out, you asked if there were any other issues. I think the point was well made a little while ago that we'll be in the middle of rules. And as we continue to change the Wyoming Gaming Commission's duties and responsibilities, and we just need to be aware of that. And we may want to have a representative of the agency there as we work this to try to, because that's going to disrupt the rule process, is it not? If we bring something brand new, we're going to have to put the brakes on that, and start over, I think. So that's an issue I thought of.
Point taken, certainly not limited to members of the legislature. Definitely need our agency partners to participate. Representative Newsom.
Thank you, Madam Chairman. I'm wondering if we want to go forward with the bill draft with these suggested amendments to Senate Enrolled Act 44 and get that kind of set up, because I know the big lift is the expansion piece.
Representative Newsom, I was going to hold off on doing that just yet. I think we need to have some more conversations with this, within this internal working group about other entities that might be appropriate to include in there. Again, I'm just worried about the fencing out. There might be other entities and some of these other affected vendors who would like to see them in other places that might be appropriate for our consideration. And so I don't want to lock it in right now within a bill draft, but I think that that can be discussed and should be discussed with our work group. I was hoping to not take motions and maybe just working through the chairs a little bit through a directive, since this is such a late meeting. Representative Sweeney.
Thank you, Madam Chairman. So I don't want to get so broad that we end up having to need a substitute bill with amendments. So I hope, I don't disagree that we need to look at what operators might be out there that we've fenced out. I don't, that was really what my question was originally on, are there other operators out there that could have possibly come to the table with this expansion piece? I think we should allow other operators as long as they meet the criteria and not fence other operators out. But I worry about getting too broad in scope that we end up losing everything because it's become too complex and we're not going to get any place. So as Senator Landon, but
Senator Grew.
Thank you, Madam Chairman. I agree with my good friend from Natrona County, and I respect the fact that you don't want to take motions this afternoon, and I'll take that for what it is. But as far as, and I'm glad to be on the working group, although today my time is a bit strange, but that was a box I did not build. But anyway, I do want to say categorically, I'd like to see pieces of Senate Enrolled Act 44 in whatever language come up. But I want to say that just because as someone potentially in the working group, I want to make sure that we do try to stay inside of some parameters on this, because if we don't, as a good representative said, I think it might just get away from us, and we do have that limited time. So
Thank you. Representative Haroldson.
Thank you, Madam Chairman. I'll jump on that team to work on that.
And committee members, I want to say, I appreciate the suggestion to keep them separate. There might, as we work this, these two issues, to me, they're one and the same. If we're going to expand, should we have the sideboards? And then how are we going to evaluate, again, through the lab report mess? How are we going to handle those new things? I mean, to me, it's like, if we don't fix and give it a whole, think about the whole spectrum, we're just going to Band-Aid another year. And some of these inherent problems that I see don't go away. And so I don't know that's where I just want to have the flexibility as this work group, as we can think about it a little bit more. Maybe it does make sense to combine them in one bill. Maybe it does make sense to have two. And maybe we have a backup in the wing that said, our intent was not to expand, and we'll revisit this in a year and just halt everything for a year until we work at another interim. That's another option too, is if we wanted to buy ourselves time to talk about expansion and really think about it, we could introduce a bill that simply says passage of Senate File 56 is not intended to authorize new skill games. Such an action would require an affirmative vote of the legislature. And then you put a pause on it, and then we study all these issues for another year. So, I mean, those are the things I think we need to sort through a little bit and give some further thought to. But this isn't, to me, it's not well, it's good for everyone. It's going to be fine. Let's just mosey on. I think we're going to hear a lot of opposition. And I just think we need to be thoughtful in that. Senator Landon.
Thank you. So I guess my question on a couple of fronts is, we may have to decide what we want to be developed in rules and what we want our legislature to be doing. And as you mentioned, lab reports and things, I guess I've always thought that should be up to the commission to decide how they're going to delineate who meets requirements and who doesn't. If we try to write that sort of thing into statute, I think that's certainly a bigger lift, because I don't really know anything about lab reports and diagnostics, and we've got gentlemen who do that sort of job for us. So I just throw that out. I mean, I don't know if we need to involve ourselves at that level, but maybe so.
Thank you, Senator Landon. The rulemaking process, I understand, is to fill in gaps. But we certainly set the policy. And so as we watch that rule promulgation, if we think that they've got it wrong, we can either swoop in with comments to the commission, or we can legislate the opposite if we think they're getting it wrong. So I think that that's an important rulemaking for us to be monitoring, and it'll go hand in hand with the work we'll do on my favorite topic. Any other comments?
Madam Chairman. So in a working group for the Revenue Committee, we, on some tax considerations, we had a couple of people that testified at the Revenue Committee. One was a lobbyist for the realtors, and the other was kind of an expert witness that had been a former county assessor that we pulled into the working group. Would it be acceptable, besides the Gaming Commission, to have industry involved in the working group's discussion?
Thank you, Representative Sweeney. I anticipate that they will be knocking on our doors to be involved, so I don't see that being a problem. I already see hands raising up out there, so I'm sure they'll be looped in at some point, if not at the outset. Any other further comments on this topic? Okay, we've got some direction. We will be, we're going to get through this week, and then I think the next order would be Chairwoman Flitner and I will visit about when our next meeting will be, whether or not we need to request additional time and how that might look. Does anyone object to trying to pick up our meeting and doing it in Casper, or would you prefer Cheyenne? Or I'm just trying to get a sense of what you'd prefer. Casper, Cheyenne? Either or, okay. I think we wanted to do Casper so we could tour the fish hatchery, and so we'll play it by ear and see if that still fits within our timeline. That might have to go by the wayside for a future meeting. So be on alert after this week of when we'll meet again, and then we'll start circulating information about this work group and how that might start taking shape. Okay, general public comment to close out our day on any of the topics or any other matter for the legislature. Mr. Agopian.
Thank you, Madam Chair. Nick Agopian, representing Bankshot LLC. Just following up on the conversation that the committee just had, since it occurred after public comment, just would like to go on the record that Bankshot would like to participate in a work group as this moves forward. I think as Representative Sweeney had indicated, I think the chairwoman had indicated you expected that. But for clarification, what will those notifications look like, and or who do I formally let know that I want to participate? Is it LSO staff, or is it just the chairwoman?
I'm on it.
Okay. Thank you.
Guessing.
But I would just like to say I'm willing to help any way possible.
Okay. Thank you. Any other comments? General public comment? Okay, seeing none, the meeting's adjourned. Good luck tomorrow, everyone.